Good morning, ladies and gentlemen. Welcome to 10th Court of Appeals, sitting in Waco, Texas, for the December the 8th, 2021 oral arguments in the courtroom. These proceedings are being live streamed for access to court provisions. Please check your cell phones, make sure they're in the off or silent positions. We do allow persons to move around in the courtroom while oral argument is proceeding, and we just ask you to do that. If you do, be courteous and try not to distract the court or the participants. We are expecting another judge to come in connection with another case. Other people may come in during arguments, and so there's only one case on the 9 o'clock docket. We do have an 11 o'clock docket today. If there are any issues that I need or that we need to take up, please notify me when I call the docket. Please announce who is going to do the arguments and whether or not time will be divided or split in any way. The case on the docket is Alliance Auto Auction, Dallas versus Lone Star Cleburne Auto.
Good morning, Your Honor. Sean Latchford here on behalf of Alliance Auto Auction. I will be the only person presenting oral arguments on behalf of Alliance.
Okay, thank you, Sean. And you can leave the mask off. That's your option, but at the table.
Thank you, Your Honor.
Morning, Chief Justice Scott Kane and Jared Hendricks on behalf of Lone Star. I'll be making all of the argument this morning.
Okay, thank you, counsel. Is Mr. Hendricks going to be added as an attorney in the proceeding?
Yes, Your Honor. I'll add him. He's an associate attorney who just got his bar card about a month and a half ago. So that's why we haven't added him until now. So
okay,
he's here mostly in observation.
Congratulations and welcome to Waco.
Thank you.
And you may proceed.
Thank you, Your Honor.
Hang on a second. Let me set your time. And we've been having some trouble with the connection for and I see that it is. High tech. Excuse me just a minute. We're going to do it the old-fashioned way. I'm keeping the counter. I'll let you know when you have 3 minutes left on your argument.
That would be great. Thank you, Your Honor.
Counsel, you may proceed when ready.
Thank you. May it please the court, counsel. My name is Sean Latchford, and I'm pleased to present this case to the Court of Appeals today. This case is a case about an automobile dealership named Lone Star, which sued an auto auction company named Alliance based on the actions of its agents who sold vehicles at Alliance's automobile auctions. The dealership's agents, Robert Russell and Bobby Hanson, were authorized to sell those vehicles at Alliance's auction through written authorizations. The written authorizations that allowed them to sell those vehicles at Alliance's auctions contained arbitration clauses, which incorporated AAA arbitration and AAA arbitration rules. When Alliance was sued by Lone Star in connection with the actions of Lone Star's agents, Russell and Hanson, Alliance sought to compel arbitration and enforce the arbitration clauses in the agreements which authorized Hanson and Russell to sell those vehicles at Alliance's auction. We're here today because the trial court denied Alliance's motion to compel arbitration and enforce those arbitration clauses. And Alliance asked the court to enforce those arbitration clauses the way that they're written and the way that the parties intended them to be enforced. This case presents two issues for the Court of Appeals to decide. First, whether the 10th Court of Appeals will join other courts in Texas, both federal and state, in finding that the selection of AAA arbitration rules constitutes clear and unmistakable evidence of intent to delegate the issue of scope to an arbiter. If the court reaches the same conclusion as other courts in Texas and across the country have reached, that will end the court's analysis, because at that point, the question of scope is no longer a question that the trial court should have decided. It is a question that the arbiter in arbitration should have reached. Because that should be the conclusion of this court, the court should reverse the trial court's order denying the motion to compel arbitration and order that the parties attend arbitration. If for some reason the court does not reach that conclusion, it will need to address the second issue on appeal, which is what is the scope of the arbitration clause at issue in this case. As the court knows from its prior opinions, there's a heavy presumption in favor of arbitration clauses. And the standard is a difficult one for the party opposing arbitration to meet. The arbitration clause must not be capable of being interpreted such that it covers the disputed issue.
I'm going to need to step back. You've pointed to an arbitration agreement in an agreement with Lone Star, or in a designation, whatever you want to characterize it. But to avail yourself of that provision, the provision requires that you be a customer of Alliance, of Auto Auction Access. We've not been through the record in detail, but is there something in the record, evidence that Alliance is a customer of Auction Access?
Yes, Your Honor. I think I understand the question, and the answer to the question is yes. There is support in the record that Alliance is a customer of Auction Access, and that comes in several forms. First, you can look at the arbitration, the terms and conditions which contain the arbitration clause themselves. They spell out that the customer, the definition of customer, includes automobile action, wholesale automobile auction companies, which is what Alliance is. So from the agreement itself, the intent is to include auction companies.
Well, under that theory alone, any automobile auction company could come in and compel Lone Star to arbitration, but they don't even have to use Auction Access. This is confusing, Auction Access and Alliance. But as I read the provision, you have to be Alliance has to be a customer.
That is correct, Your Honor.
And so where is the evidence that Alliance is a customer of?
Your Honor, in the original motion compel in the trial court, submitted with the motion compel was a complete list of the customers that are customers of Auction Access. That was attached to the original motion to compel. It's included in the clerk's record at page 123. 123 is one section of the page of the exhibit attached to Alliance's motion to compel arbitration. That page specifically identifies Alliance Auto Auction of Dallas as a customer of Auction Access. And it also identifies all the other customers of Auction Access at the time that website was accessed.
Okay, so if we agree with you that you're a customer and the arbitration provision could be applicable, is there a difference in your mind between the Kellogg discussion from the Supreme Court of the scope of the arbitration provision versus the arbitrability of the dispute?
No. Is the answer to your question, Your Honor. I don't believe there's a distinction with respect to whether or not the delegation exists to an arbitrator. The issue is whether by agreeing to AAA arbitration rules, the parties have agreed that in the first instance, the scope, who it is that's governed by the arbitration clause itself, or what disputes are governed by the arbitration clause should be considered by the arbiter. And other courts have found similar indications, specifically the Alabama Court of Appeals, and as the court knows, the choice of law selection in this agreement is Alabama law. Since the briefing is completed on February 7, 2020, the Alabama Supreme Court issued an opinion called Wiggins versus Warren Averett. That's 307 SO 3D 519. In that opinion, the court considered whether a non-signatory could be compelled to arbitration based on AAA arbitration rules. And the Court of Appeals the Supreme Court in Alabama found that AAA arbitration selection did require that party, even as a non-signatory, to arbitrate the issue of whether the non-signatory was bound by the arbitration clause.
Okay, but in this arbitration provision, it didn't, how can I say it? Conclusively appoint AAA. It did not designate them. Y'all have the option to do that. That would seem to not invoke the AAA rules until a subsequent determination and whether or not that is effective. So how would you address that?
Respectfully, Your Honor, I would disagree. I don't believe that the way that the text of the parties arbitration clause is stated should be construed as not selecting AAA arbitration. And there's two reasons for that. One, Lone Star characterizes that portion of the arbitration clause as a fallback clause. Alliance characterizes it as a default clause. But in either instance, I don't think that there's any authority to support the notion that because the parties have agreed to a provision by default, they haven't reached any agreement concerning the provision. Secondly, and I think that position is also supported, the Dallas Court of Appeals in the Home Advisor case, which was also issued after the briefing in this case was completed. The citation for that is 2020 Tex App Lexus 4226. In that case, the Dallas Court of Appeals considered an arbitration clause which included language unless Home Advisor, one of the parties, agreed to other rules, AAA arbitration rules would apply. And in that instance, the Dallas Court of Appeals found the AAA arbitration rules did apply. And because of the AAA arbitration rules, the question of scope is delegated to the arbiter. So the only authority I've been able to locate indicates that even if you have an unless or a conditional or default clause, that clause is still a selection of AAA arbitration rules unless the parties have reached an agreement otherwise. And that's the second point, Your Honor. Alliance hasn't agreed to any other rules. And it's stated in the briefing that Alliance doesn't intend to agree to any other rules. And as a result, as a practical matter, the rules that are selected by the parties are AAA arbitration.
But we've got to go with the agreement as drafted as determining who's going to decide this scope question. And you just cited a Texas case that for that proposition, you also cited apparently a Alabama.
That's correct, Your Honor.
Neither of which is where this arbitration was to go, if I recall. It was.
No, it's Alabama.
Was it Alabama? Okay.
Alabama.
Okay. For some reason, I was thinking the arbitration was to be in Tennessee if it was going to be elsewhere. But the question about that, whether or not it's well, I guess I should say, is that your only basis for a forum, or excuse me, a choice of law provision is the arbitration provision?
Your Honor, the choice of law provision is not actually in the arbitration clause itself. It's part of the terms and conditions that are incorporated into the authorizations that gave Russell and Hanson the ability to sell vehicles. So it's part of the general agreement that forms the basis of the parties' dispute, which is outside of the arbitration clause. And more, I think, directly to Your Honor's point, I'm not sure that it really matters, the distinction between the Texas cases and the Alabama cases. This is a case that it doesn't appear there's any dispute is governed by the Federal Arbitration Act. And so generally speaking, these types of arbitration agreements should be interpreted consistently between the states. And neither of the parties have pointed to any significant differences between the Alabama court's interpretation of arbitration agreements And the Texas interpretation of arbitration agreements, they appear to be consistent in that regard.
And did the choice of law provision, was it argued at the hearing, and was the court asked to take judicial notice, or was it presented as exhibits to the trial judge?
I believe that the choice of law provision is in the agreement, which was presented in the briefing to the trial court.
I'm talking about okay. Yeah, I'm sorry, I cut you off. Go ahead.
And so I believe that the issue about Alabama law was briefed. Both the parties in the trial court and in the appellate level have essentially agreed that Texas and Alabama law with respect to the arbitration provision is consistent. And so it's a distinction without a difference in this instance. So I think the court can fairly look at the interpretation of arbitration clause in Texas courts and Alabama courts, especially those that are governed by the Federal Arbitration Act, because they're interpreted consistently.
Okay. Humor me that we are not convinced by your argument that AAA gets to be that's not the first exit that we take. And there has to be a determination of whether or not this dispute is within the arbitration provision. And the relevant language is that it has to be related directly or indirectly to this agreement. How is the facts and claims of this dispute in any way related to this agreement?
I think the short answer, Your Honor, is there is no dispute without these agreements.
I understand that, because you posited that your client, their client, and although I didn't get into the details, that there was some reason auction access was the connection between these, and we'll peel that onion if we have to. But where is the connection? What went wrong with the agreement?
I think the short answer is whether or not those individuals were authorized to sell the vehicles. Lone Star's allegation is, and as this court knows, the LDF.
That would be if they're authorized to sell them through auction access. That's all these designations did. They were authorized to sell the automobiles because they were licensed real estate or licensed automobile dealers.
Respectfully, I disagree, Your Honor. The authorizations are providing authorization for the agents of Lone Star to sell vehicles at auction. And if you look at the first sentence of the authorizations on page Clerk's Record 44 or Clerk's Record 50, the authorizations state that the purpose of those authorizations is to be provided to auctions, wholesale auctions, dealership auctions, customers of auction access, so that they know who is authorized to sell the vehicles. Lone Star doesn't need an authorization for its individual employees to sell to consumers, for example, because they're at the dealership where they're selling it. So there's implicit authority. The problem is for third parties like auction companies like Alliance, how do they know whether or not that person has authority to actually do what it is that they're doing, buying and selling vehicles? And what auction access does, which is very important, is checks the credentials of the dealership to make sure that they're licensed. It also tracks who can act on behalf of those dealerships, because many people show up to these auctions. And it's very difficult for an auction company to determine if Justice Gray shows up at an auction, does he have the actual authority and the legal permission to purchase a vehicle at an auction, which is only allowed to be purchased by a licensed dealership in Texas. And so in order to do that, companies like Alliance contract with auction access, which is what the authorization states, that it'll be provided to those companies and used for that purpose to determine that they have the authority to do those things. And
But do we have anything in the evidence or in the claims that says that that's what Alliance was doing at the time that these claims and their connection to this claim, that they were even these automobiles that were bought and sold and created the problem for Lone Star, that was being conducted through auction access?
there's no allegation about auction access, and I think that's intentional and clear from Lone Star's argument. And the problem is that each of those statements are implicitly through auction access because there's no other way for those agents, Russell and Hanson, to participate in those auctions unless they're authorized. And the record includes, excuse me, the record includes Alliance's records which show who is authorized for Lone Star to act on their behalf, which was submitted to the trial court. And so you don't just have to look at the authorizations, you can look at Alliance's internal records that shows these are the people we have from auction access who are authorized to act on behalf of Lone Star. And so in the petition on page Clerk's Record 11, when Alliance says sending cars through auction by Russell and Hanson, what they mean is the authorized sale of vehicles through Alliance's auction. And Lone Star is very careful in the briefing to try and characterize this as participation. But what they really mean is buying and selling vehicles at auction, which is exactly what the authorizations authorize those individuals to do. I think the other place in the record that the court can look to answer that question is Alliance's affirmative defenses, which are in the pleadings and in the records. One of the defenses that Alliance asserts is that there's an indemnification agreement in those authorizations. Specifically, Lone Star said it would indemnify customers who are auction companies if its agents took actions at those auctions which subjected Alliance to liability, which of course is exactly what Lone Star is alleging against Alliance in this very suit. And so it's a circular pattern, Your Honor. Lone Star has alleged that Alliance did something wrong because of the actions of its own agents, which are indemnified in the very agreement that includes the arbitration clause. And from this court's opinion in LDF construction, it knows that the test is you compare the language of the arbitration agreement, which in this instance is very broad and sweeping, any controversy or claim related directly to that authorization or indirectly related to the authorization, to the language of the petition or the claims and defenses involved in the case, sending cars through auction, authorizing the sales of vehicles, which specifically takes place under those authorizations. And when you consider the heavy presumption established by the Federal Arbitration Act, it's very clear that this is not a case where the arbitration clause is capable of any interpretation, which would not cover the disputed issue here. And for that reason, we would say that it's clearly within the scope of the agreement. There are some arguments that Lone Star advances against that interpretation. The first one is that the term of the agreement is limited. And I want the opportunity to address that because I think it's important to be clear that Lone Star has severed part of the definition of agreement. If you look at the actual record at page 57, Lone Star excluded the second half of that definition, which includes any other agreements between you and us, such as the authorizations. Those would be agreements which are signed by Lone Star and its representatives and submitted to auction access. And thus the terms and conditions, when Lone Star says it's just the system, just registering and being in the system, that's just simply not true based on the text of the record before the court. The other agreements, including the authorization and Lone Star's use of those authorizations, would be included in the nature of the agreement. And that's why I've been arguing that all of this really boils down to the authorizations themselves are the turning point for the dispute, the relationship between the parties. It's true that Alliance says there's no proof that auction access is the only nexus between the parties, but we don't have to show it's the only nexus, just that it's the nexus here. And that's what those authorizations do. Because of the allegations that Lone Star has made in the petitions about sale, those authorizations are the fundamental connection, in this case, based on these facts of the arbitration clause. And that's why we believe it's within the scope, Your Honor. And I see that I'm out of time.
Yeah, I noticed that it started to work. Question? You'll have 5 minutes on the vote.
Thank you, Your Honor.
May proceed when ready.
May it please the court, opposing counsel. Justice Gray, you're absolutely correct in looking at the relationship because as this court knows through its previous decisions, as well as all of the Texas jurisprudence, Alabama and federal jurisprudence, the issue is you've got to have a connection to the actual contract where the arbitration clause is, and there's no connection in this case.
Why is his argument that the designations of them as agents on behalf of Lone Star not adequate?
When you look at the registration that he talks about, and this is Appendix E to their appellate's brief, this is the terms and conditions of the agreement between Auction Access and Lone Star. So that is the contract by which is the genesis for the arbitration clause, which, by the way, you've got to go through a point and click through several websites, and you got to connect the dots. For example, it doesn't say in that the customer section, you got to go to a different web page to find out who the customers are and who you may be bound by. But when you look at that agreement, when you talk about the registration that he keeps talking about, the registration is to use the auto access services. For example, if you look at paragraph 2 of the Appendix E, use of the auction access system registration, and this is their document. To use the auction access system, you must register with us by completing a registration application form and providing other information as requested. So what they want to do is they want to take that registration and they want to say that they're basically auto access is a credentialing service, but that's not the case. When you look at paragraph 1 of the agreement, it talks about the agreement, and it's capitalized, the auction access agreement. That is the agreement where it talks about all of these services that auction access relates to. So in other words, for there to be a nexus between the operative facts of this lawsuit over our Texas tort claim under Kinsbach-Toole, knowing participation and breach of fiduciary duty, you've got to have a relationship to the auto access contract and services. So in other words, if the case had been such that they were using, they being the employees, were using the online access to the auction through auction access to perpetuate their fraud and to cover up their tracks, then you might have some nexus, but that is not the case. When you look at the petition, that is not the case at all. We haven't alleged that because it didn't happen on that. There simply is no nexus or connection to that. And so you have to look at that connection. For example, this court previously in the Dennis case, when you look at arbitrability on non-contract claims, which by the way, in the Dennis case, you had an issue of contract and non-contract but the same parties. Here you've got a little bit further apart where you have a non-party or a third-party beneficiary. In the Dennis case, under the third-party beneficiary, this court had indicated that you have to have a little bit closer nexus than just the more liberal or more broad approach that was used compared with the Eastland court and some of the other courts that had a closely related test on that. And this court said, claims against a non-signatory to an arbitration agreement are subject to arbitration if the claims against the non-signatory are based on the same operative facts and are inherently inseparable from claims which could be asserted against a signatory to the agreement. So you have to, when you start talking about forcing an arbitration clause on a party that didn't bargain for and consent to that in the operative facts, you got to have a nexus to that. Now, they have argued in their pleadings over and over that this but-for test, but for this registration, we would not have been able to provide services. But at the trial court, they even mentioned there are other service providers like Mannheim, and you have the ability to physically go and have that relationship, which is the operative facts in this case. So you can't just argue a fact into existence, which is what opposing counsel has tried to do at the trial court, in the briefing, and even oral argument here today. But he cannot show a nexus to the actual auction access contract because there were no online aspects on that.
Am I understanding that your pleadings and your case is built upon not using auto access?
It doesn't mention it because it didn't happen. Our case is predicated upon Alliance knowingly participated in a breach of fiduciary duty through the cover-up.
Personal contact and direct relations between Lone Star and Alliance, not with a triangular point, directly or indirectly through auction access?
That is correct, Justice Gray. Our allegations in this case are that the two employees parked cars They took cars, they actually drug cars that were inoperative over to the auction, left them there for days, communicated with Alliance directly. All of that was physical and was not through online presence, through auction access. There is no connection through online, through auction access whatsoever on that. And so even if this court took a broader approach in trying to determine whether or not the claims are under the scope of this arbitration clause, you still required in the Dennis case that the non-contract claims have to touch matters related to the arbitration clause and have some significant relationship or be inextricably intermeshed or factually intertwined. You've got to have some nexus or connection to the arbitration clause. And so it's really important when you look at the agreement with auto access, what that agreement is in context. And in that case, for them to get to the issue of who determines arbitrability, they have to, it's a house of cards, their argument. First of all, they don't have a direct contract with Lone Star. You've got to go to a third-party contract, auction access. Then you've got to go to an online policies and procedures. But then, as Justice Gray pointed out, there's a real particular word that they want to gloss over. They want to change the wording of the actual arbitration clause that they're wanting to enforce from if to unless. And those are words that have a very distinct difference. If is a conditional word. So the arbitration clause at issue that they're trying to enforce says that the parties will reach an agreement on an arbitrator. If they don't, then AAA is the fallback. Then you've got to go to AAA and find an obscure provision regarding who determines scope of arbitrability. But quite frankly, when you look at Texas law, federal law, and even Alabama law, the majority of cases dealing with an arbitrator determining scope is dealing when you have a blended issue of contract and tort claims and whether or not those go together, not third-party beneficiary and this gatekeeper function. If opposing counsel's right, then we have just abdicated all gatekeeper functions in our Texas district courts to other states through an arbitration clause. And that's really at the heart of this case, is what they are seeking to do is to take a purely Texas tort claim on its face and genuinely, when you look at the facts, the operative facts, a purely Texas common law case, and they want to send between a Texas plaintiff and a Texas defendant. And they want to send this case to mandatory arbitration in Alabama, in Birmingham, Alabama, with an arbitrator from Alabama. And they don't, essentially what they want to do is they want to elevate this arbitration clause above even the Texas Constitution, to be real blunt. And that's why the United States Supreme Court in the Leland case in 1989 said that arbitration is a matter of consent, not coercion. Very important when you frame that. That is still the law. And our Texas Supreme Court case said in Davidson versus Webster in 2003, and I quote, "The purpose of the FAA was to make arbitration agreements as enforceable as other contracts, not more so." If the court adopts the proposition that the appellants alliance are arguing today, then you will be elevating a third-party contract and an arbitration clause above the Texas Constitution by allowing that to determine who determines this gatekeeper function that we historically do in Texas.
Isn't it entirely possible that if we accept their position, that the arbitrator in Alabama, did I get that right this time? Yes. Is going to say this dispute doesn't touch auto access agreement. And so this is not an arbitrable provision.
That is definitely a possibility. However, the key issue is not determining the scope of what's going to get arbitrated, but whether or not this arbitration clause in a contract, third-party contract applies. And so to abdicate that to Alabama law would put Texas law subservient to the state of Alabama instead of on a level footing.
So I take it you think there is or may be a difference between the scope of the arbitration provision and the arbitrability of a dispute.
I do, Justice
So
Gray.
you think that regardless of whether or not AAA has is authorized to do the arbitrability question, that the Texas courts still have to determine whether or not there is a arbitration provision that applies to the dispute?
I do, Justice Gray, because you still have the job and the duty of interpreting the contract. And sometimes we get into the weeds and we forget that we're looking at the four corners of the contract. And you have to apply Texas law and determine that contract and intent, just like forum selection, choice of law, and any other provision. And you give that equal dignity with the arbitration clause. If you adopt their position, then you're taking one clause and elevating it above the others. And it's important to note too, when you take a look at that agreement, it's kind of interesting, but they also have the ability to enforce it or not enforce it. When you look at paragraph 10 in Appendix E of that third-party beneficiary provision, says our customers, and again, you got to go and you got to search and scour the internet to find out who the customers are third-party beneficiaries of this agreement at their election and in their sole discretion, you agree, and then it goes on. So you have some mutuality issues, even if you were to go down that trail of whether or not this is a binding arbitration clause. And there's some good Texas case law over the last few years that talks about mutuality when you have an arbitration clause. But at the core, there's got to be some connection to the contract that they're pulling this arbitration clause through, and they can't get there.
What if the evidence is y'all proceed in discovery after this suspension, you wind up finding some transactions that were conducted online?
In that case, Justice Gray, the courts and the case law determining how you determine scope of arbitrability, you don't make that inquiry. You don't go through discovery. You look at the pleadings and the operative facts that have been pleaded in that case. So,
but I'm saying if you go through and the operative facts are developed that there is some of these transactions that were conducted through the internet auction access. Can they trigger the arbitration provision then?
I believe they can, because at that point, let's say hypothetically, you go through discovery and you find out that the Kane was wrong and 90% of the cases involved in the operative facts in this were done through online. They could re-urge the arbitration clause based upon that discovery of new facts and new information. But that isn't the case. But when you're looking at it from the perspective we are today on the front end, the Texas case law is very clear that you look at the operative facts as pleaded in the pleadings on that. I don't have to, in other words, they have to show the connection and nexus if they want to enforce that. It's not my duty to disprove a negative, so to speak. And so that is really the key question. I think what is really interesting when you really step back and you take a 30,000-foot view of what's going on here, opposing counsel at the trial court and trying to describe the relationships in these third-party beneficiaries, he made a reference to analogous to eBay. If you have two members that have an eBay contract and in their policies and procedures somewhere on the internet, it says you've got to arbitrate those issues and you have a dispute, and he likened it to that. So if you take that illustration, what we have in this case in the operative facts would be akin to both parties being members of eBay, being part of this club to be able to do online auctions. And then, one party runs into the other party out on the street, steals his wallet and gets sued for theft. And then the other party says, no, wait a minute, we're both members of the same club, eBay, and it has an arbitration clause that's got the same language as this one. You have to go arbitrate that. That's how absurd this is in this case, is they are seeking somebody else's, they want to commandeer somebody else's arbitration clause for a club or an online provision. And auction access is not a credentialing service that would be like background check for employees or something of that nature, but they are an online service that allows dealers to be able to go online anywhere in the country, look at the auction, see that, make bids, and work on that. And so the documents, the application or registration that is referenced in this case is to use those services. That has nothing to do, and there is no nexus with that. And for those reasons, we say that the court below got it correct. And this wholly Texas common law case, there's no way that Lone Star could have anticipated or ever dreamt in their wildest dreams that they would be held into arbitration in Birmingham, Alabama, applying Alabama law that they have no connection to with an Alabama arbitrator. And you've got to connect the dots, so many pieces and parts of the internet, click-throughs and different things. And it's just too tenuous under either the Dennis approach or the Great Western approach, whatever analysis this court does, they can't get there. There is no nexus other than their but-for argument that also fails because there's no evidence to support that. So we would respectfully request the court to affirm the court below.
I just have one question. I haven't looked at the, pardon my voice, it's the 80 degrees yesterday, 50 degrees today deal that we're going through. There is a process by which it looks like you would do things. First of all, you decide there's some kind of dispute. Then you say, okay, non-binding mediation. Then if non-binding mediation doesn't work, then the first choice is somebody in Birmingham who happens to be an ADR guy, and you use their rules. But if you can't agree on that, then has any of that happened before the suit was filed?
It is not, Justice Smith. We filed, obviously, we had no earthly idea that we were going to be told we got to go arbitrate these claims. I believe this court had directed us to go to mediation.
I know we did.
And that was unsuccessful at this stage of the case, given what's in controversy and what the issues are. But I think you're right. There's a process, even if you were to say that that applies, which we say we don't even get to that point. But if you do, just to get to who determines the scope, they have to go all the way through step after step after step, inference upon inference to get to the AAA. And then you find an obscure provision. But that word if is conditional on that. And that word has a very important meaning when you look at that.
Thank you, counsel.
May it please the court, counsel, there are a couple of clarifications in the record that I'd like to make. And before I get to those record citations for the court, I'd like to turn the court's attention to the Wiggins opinion I cited in my initial argument. This is that 2020 Supreme Court opinion from Alabama. If you look specifically on page 522 of the Alabama Supreme Court's opinion, the Alabama Supreme Court says, our case law holds that whether the scope of an arbitration provision applies to non-parties or non-signatories to an arbitration provision is also a question of arbitrability. So I do not have a Texas case law stating the Texas case stating the same, but I can tell you under Alabama law, the Supreme Court is very clear that the question of whether an arbitration agreement applies to a non-party is a question of substantive arbitrability, and an arbitrability question that in our instance should be resolved by the AAA arbitrators. And that's why I pointed the court to the Wiggins opinion. I do want to clarify a couple of the record references that were made in opposing counsel's argument. The first is that Alliance Auto Auction or auction access is not a credentialing system. And if the court looks in the clerk's record on page 41, this is a copy of Auction Access's webpage, their homepage, actually, at the time that the motion to compel arbitration was filed. And the first sentence says, Auction Access is the #1 dealer credentialing system for the wholesale auction auto industry in North America. Auction Access provides security and convenience for our auction and dealer partners by securely limiting wholesale access to licensed credentialed vehicle dealers and their authorized representatives. The record, the only evidence in the record establishes that Auction Access is the gateway for dealerships into wholesale auctions like Alliance. But moreover, opposing counsel argued that auction access is only online, but that same page in the record says auction access card is a dealer's gateway into the wholesale auction physical and online lanes. The only record in the case is that auction access is the key that unlocks wholesale auctions. And in this case was the actual key that unlocked Alliance's auctions.
But therein, when you said actual key that unlocked it, where is the connection between the transactions between Lone Star and Alliance that are at issue in this lawsuit?
The connection is the sales of the vehicles in the petition, Your Honor.
And where is their connection in this record to auction access and a use of their provisions?
It's the sale. There's no specific reference in the record, and it wouldn't really make sense for Lone Star to do this, but there's nothing that says they sold vehicles through Alliance's auctions using auction access, because the only way that they were allowed to sell the vehicles through Alliance was through auction access. And so implicitly, whenever it says sale or sold.
Are you telling me that every automobile bought and sold by Alliance is done through auction access?
Yes, Your Honor. The dealers.
And is that in the record?
There's no, the only record statement concerning that is that Alliance requires dealerships to register. Now, the problem is.
Wait a minute, who requires?
Alliance requires dealerships to register before they can participate in automobile auctions. And the way that they do that is through auction access. But I think Your Honor's next question is going to be, does it say auction access? And the answer to that question is no. And that's because Alliance uses auction access for all of its registration. And that's why the record, the documents in the record in this case about the relationship between Alliance and Lone Star are all from auction access, because the way Alliance verifies dealers' credentials and authorized representatives is by contacting auction access, who maintains the records. And that's the second thing in the record I want to clarify, Your Honor. It referenced that the agreement is the terms and conditions. And to be clear, that doesn't even make any sense. No one just agrees to terms and conditions. They agree to an agreement which incorporates the terms and conditions. In this case, the agreements which incorporated those terms and conditions are the individual authorizations for the individuals who sold vehicles at auction. That's the basis for Lone Star's claim against Alliance, that these individuals wrongfully did that. And if you look at the authorizations, the first one on 44, it specifically says that the individual authorized, Russell in this instance, may buy and sell automobiles for you. That's the purpose of the agreement, is to extend the authority of Lone Star to those individuals. The last thing I want to point the court to is the record reference for the link to the customers, because I think the court has had a question about whether there's any evidence to say that Alliance is the customer. And if you look in the clerk's record at page 26, there's a link to the website for auction access, which now is a little fancier than it was at the time. It used to just be a list, but now it's actually a website where you can search. And even today, you can still search and find that Alliance is identified as a customer of auction access.
Is there a difference between a customer and a subscribing customer?
No, Your Honor, there's no difference between a customer and a subscribing customer, because the customers of auction access are the auction companies. The members would be the dealerships who register and submit authorized representatives so that they can participate in those automobile auctions. And opposing counsel mentioned Manheim as one example. Manheim is not another system for registering individuals. It's another automobile auction company. And you can confirm the same by looking at the list of customers, of which Manheim is one of, auction access, because auction access provides the credentialing systems for Manheim, which is another physical auto auction. Unless the court has any other questions.
I'm trying to formulate it. If one of the other judges has a question, go ahead. I want to make sure I understand that you're saying that Alliance does not buy or sell any automobiles other than through auction access.
That's correct, Your Honor. It's an auction company, and the eBay analogy was.
They don't use any other service like Mannheim or anything like that?
No, and I'm relatively confident in that, and I can tell you from the record, there's no indication of that, that there's any other way to verify those individuals. And that has to do with the number of dealerships that there are in Texas. If you think about it as a practical matter, Sally shows up at the auction. How do you know if Sally is actually authorized on behalf of a licensed dealer? Because only those licensed dealers can participate in the auction under Texas law. To coordinate all that information, they subscribe to Auction Access, and that's how they coordinate who it is that's authorized. They actually, in the record, there's a reference about using badges. The people who actually show up at the auction, they use a badge to indicate that they have authority and that they're registered through Auction Access. And that's how the auction company, much like eBay, can verify whether or not the person is a user and is registered to be able to participate in auctions.
Okay. So you're saying there's a distinction at auction access between customers and members, that dealerships like Lone Star are members and auction companies like Alliance are customers.
That's correct.
How does, and this is only for background information so that I can understand the facts and the judges kind of grapple with this. How does auction access make funds? I mean, where is their revenue stream from?
It charges the customers and I believe the members also for their registration. Now, the members part I'm not sure on, but it charges subscribing customers to manage that data. And that's why I raised the complexity of figuring out who's authorized, and who's licensed, and who's a dealership and who's not, because that's a lot of work. And so auction companies like Alliance are willing to pay somebody else to be the holder of that information so that when a dealership representative shows up, they can scan a card and say, oh yeah, you can participate.
Okay, but if the I'm sorry, I'm getting it too far outside the record. I'll stop where I've gone. So any other questions? Questions? Thank you, counsel.
Thank you, Your Honor.
This case is submitted and y'all are excused. I will